Welcome back to the deep dive. We're continuing our series exploring the manual of patent examining procedure section by section, really trying to get under the hood of U.S. patent practice.
Yeah, exactly. We're trying to make this a bit of a shortcut for you, whether you're prepping for the patent bar, maybe trying to figure out international filings, or, just curious about how this whole system works.
We aim for clarity, keep it concise if we can, but definitely get into the details.
Absolutely.
So today, we are zeroing in on MPEP Section 1862.
Right. And the title itself gives a pretty big clue. Agreement with the International Bureau to serve as an international preliminary examining authority.
Okay. And just to place that for everyone, Section 1862 is tucked inside Chapter 1800.
Which is the big one covering the Patent Cooperation Treaty, the PCT, specifically the international phase of the PCT process.
Right, that whole international system for filing in multiple countries with one application. And before we really jump in, just want to give a quick thank you to Mike Shepard.
Oh, yeah, big thanks. He's been instrumental in organizing this whole audio series.
Definitely appreciate that. Okay, Section 1862, let's dig in. What's the main point here, the core function?
Well, the main thing Section 1862 does is explain how the U.S. Patent and Trademark Office, the USPTO, gets its authority to act as an international preliminary examining authority. Usually we just say IPE for short.
IPEA. Okay, so it's another role the USPTO plays in the PCT system. We know it can be a receiving office where you file.
Right.
And it can be an international searching authority or ISA doing that first search.
Yep.
But IPE, that sounds like examination, right? Like the next step.
Exactly. The PCT system has this optional second stage in the international phase called International Preliminary Examination. And Section 1862 basically says, yes, the USPTO is one of the offices that can do this job. It's authorized to be an IPA.
Okay, so they can do it. But how does that authorization actually happen? Is it just internal USPTO policy?
No, it's more formal than that. It comes from actual agreements. Specifically agreements between the USPTO and the International Bureau of WIPO.
WIPO, the World Intellectual Property Organization, they run the PCT show.
Pretty much, yeah. They oversee the whole system. So these agreements are key.
Okay, USPTO and the International Bureau make an agreement. What's the underlying legal power for that? Like internationally and then here in the U.S.?
So internationally, the framework comes directly from the PCT treaty itself. Section 1862 points to Articles 32 and 34 of the PCT. Those articles lay out the whole concept of international preliminary examination and how offices get appointed as IPEAs.
Got it. Treaty sets the stage. Then how does the U.S. bring that home?
Right. So here in the U.S., the specific authority for the USPTO to actually participate comes from our federal law, Title 35 of the U.S. Code.
Okay.
Section 1862 mentions 35 U.S.C. sections 361C, 362, and 364. These basically give the director of the USPTO the green light to enter into these kinds of agreements, like the one with the International Bureau, to act as an IPEA.
So treaty framework enables it. U.S. law lets the USPTO join the party. Is there a specific regulation that gets into more detail?
Yeah, there is. The nitty-gritty, you could say, is in the U.S. regulations. Specifically, 37 CFR Section 1.416. That reg is pretty important for understanding when the USPTO can step into this IPEA role.
Okay, 37 CFR 1.416. What does it say about the scope? Like, can the USPTO only be the IPA for applications filed in the U.S.?
Good question. And no, it's broader than that. That's what 1.416 clarifies. It says the USPTO can be the IPEA, yes, for PCT applications that were first filed right here, using the USPTO as a receiving office.
Right, that makes sense. File here, examine here.
But it also says the USPTO can act as IPEA for applications that started somewhere else, filed in a different country through a different receiving office entirely.
Really? So you could file in, say, Japan, but ask the USPTO to do the preliminary examination?
Potentially, yes. If there's an agreement in place between the USPTO and the International Bureau that covers that specific scenario, it depends on those agreements.
Interesting. So it expands the possibilities.
It does. And the regulation also mentions that the USPTO can serve as IPA if it already acted as the International Searching Authority, the ISA, for that application.
Okay, so there's often a link. Did the search, can do the examination, but not always required, depending on the agreements.
Exactly.
So let's say the USPTO is the IPE for a particular application. What happens then? What are the actual jobs they do in this role?
Okay, so the process kicks off when the applicant files something called a demand That's the formal request for this preliminary examination.
The demand. Got it.
The USPTO, as the IPEA, receives that demand. Their first job is to review it, check for any formal problems. Is it signed, filled out, right? That kind of thing.
Standard procedure checks.
Right. And of course, they collect the fees.
Naturally. Always fee.
Always fees. But then they also do some more substantive checks early on. A really key one is looking at whether the claims meet the unity of invention requirement.
Unity of invention again. We talked about that with the ISA search phase. Why does it matter again here during examination?
Yeah, it's a good point. It comes up again mainly for, well, efficiency in the examination itself. The whole point of this preliminary exam is to give an opinion on one core inventive concept.
Okay.
So if the application tries to cover like 5 different inventions that aren't related, the IPEA isn't really set up to examine all 5 under one demand and one fee.
Right. Keep it focused. I think the source material mentioned an example of this.
Yes, it did. A pretty clear one. Say you file a demand and your claims cover maybe a new kind of bicycle gear system, but also a completely unrelated chemical process.
Yeah, those sound pretty different. No unity there.
Probably not. So in that case, the USPTO as IPEA wouldn't just start examining both inventions. They'd likely send an invitation to the applicant.
An invitation to do what?
To restrict the claims. Basically, hey, you've got 2 inventions here. Pick one you want us to examine under this demand.
So the applicant has to choose, or maybe pay extra.
Exactly. They can choose to restrict to one invention for this preliminary examination, or sometimes they might be able to pay additional fees to have the second invention examined too. But if they don't restrict or pay up,
Then what?
then the IPA will usually just examine the claims relating to the first invention listed. It keeps the process manageable and focused on a single concept per fee.
Okay, makes sense. So checks the demand, collects fees, checks unity. What's the main event? The big output of this whole IPEA process.
Right. The main reason an applicant files the demand is to get the International Preliminary Examination Report, the IPEU.
The IPER. Okay, what kind of report is this? Is it like getting an office action from the USPTO during national examination, saying claims are rejected or allowed?
No, and this is probably the most critical thing to understand about the IPEA. It is explicitly, and I mean explicitly, a non-binding opinion.
Non-binding. Hold on. So the USPTO, acting as IPA, does all this work, looks at prior art, analyzes novelty and inventive step, and the result is just their opinion. It doesn't actually decide if you get a patent anywhere.
Correct. It's an opinion, a well-reasoned expert opinion based on the PCT standards, but it does not bind any of the national patent offices later on.
So when the application goes into the national phase in, say, Germany or China or back here in the U.S., those offices can completely ignore the IPEA.
Legally speaking, yes. They conduct their own examination according to their own national laws and practices. They are not bound by the IPEA's opinion.
Wow. Okay, that seems almost pointless then. Why pay for a non-binding opinion?
But it's definitely not pointless. Think about the value of the information. Even though it's non-binding, the IPEA gives the applicant a really valuable early assessment of their invention's prospects against global standards.
Okay.
It's like getting a sneak peek. Before you spend potentially huge amounts of money entering the national phase in 10, 20, maybe more countries, you get this detailed opinion from an expert authority like the USPTO.
So it helps you strategize. Decide where to file, or maybe if you need to amend the claims first.
Yeah. Exactly. It helps you gauge your chances. And it tells you specifically what the IPA thinks about the core patentability requirements under the PCT.
Which requirements does the IPEA actually cover?
It focuses on the big 3 under the PCT. Novelty is the invention new. Inventive step, which is basically the PCT term for non-obviousness. And industrial applicability, can the invention be used in industry?
Okay. Novelty, inventive step, industrial applicability. So the report might say claims 1 to 5 appear novel and involve an inventive step, or maybe claim 6 seems novel but lacks inventive step, that sort of thing.
Precisely that kind of opinion. So if you get a really positive IPEA, you might feel much more confident about filing widely in the national phase.
And if it's negative?
If it's negative, it's a serious heads up. Maybe you need to amend your claim significantly before you even think about the national phase. Or maybe you decide to only enter in a few key countries where you think the law might be slightly different or you have a better argument. Or in some cases, a very negative IPEA might lead an applicant to just abandon the application altogether, saving a lot of future cost.
Okay, so huge strategic value for the applicant. What about the national offices? If it's non-binding, do they just toss it in the bin?
Not usually, no. While they aren't bound by it, Many national examiners find the IPEA very useful. It gives them a starting point.
How so?
Well, it summarizes the IPA's thinking, points out the relevant prior art they considered, and gives that opinion on novelty and inventive step. For a busy national examiner, that can potentially speed up their own examination, especially if the IPEA was positive and well-reasoned. It doesn't replace their work, but it can inform it.
So it's non-binding, but still influential. A practical tool.
Exactly. It greases the wheels of the system, providing information efficiently.
Got it. Now, you mentioned earlier that Section 1862 points toward the actual agreement between the USPTO and the International Bureau.
Yes, it does. It tells you that agreement exists and, importantly, that you can find it on the WIPO website.
Why would someone want to look up that specific agreement? What's in there?
That agreement is like the detailed rulebook for the USPTO acting as IPEA. It spells out all the specific procedures, the timelines, how fees are handled, the exact scope of the examination authority granted to the USPTO, the reporting standards they have to meet, all the operational details.
So it's the fine print that governs how the USPTO actually does the job of being an IPEA.
Precisely. And having these formal public agreements is really important for the overall PCT system. It helps ensure that the process is, harmonized and predictable, regardless of which office is acting as the IPEA. Applicants need that consistency.
Yeah, predictability is definitely crucial when you're dealing with something as complex as international patents.
No question.
Okay, so let's just quickly recap. MPP Section 1862 establishes the USPTO's authority to be an international preliminary examining authority, an IPEA, within the PCT system.
Right, and that authority comes from its summons with WIPO's International Bureau, backed up by both the PCT treaty itself and specific U.S. laws and regulations like 37 CFR 1.416.
And the section outlines the key jobs the USPTO does as IPEA: receiving the demand, checking formalities, dealing with unity of invention.
And, most importantly, issuing that International Preliminary Examination Report, the IPEA, which is, critically, a non-binding opinion on novelty, inventive step, and industrial applicability.
But a very valuable opinion for strategic planning.
Absolutely. And the section points you to the underlying agreement on the WIPO site for all the procedural details.
Okay. Before we wrap up, we need to include our usual disclaimer.
Right. Just a reminder, this summary was put together using AI tools like ChatGPT and Notebook LM. While we try our best, it might have errors or omissions. It's really just for educational and informational purposes.
It's definitely not legal advice, and it's no substitute for reading the official MPP, taking a proper course, or talking to a registered patent attorney or agent.
Please consult those official sources for any authoritative guidance.
Very important. Okay, so we've covered the mechanics of Section 1862. Let's leave our listeners with something to chew on, a final thought.
How about this? Think about that non-binding nature of the IPR. How does that really affect an applicant's strategy? If you get a stellar IPR, how much confidence does that actually give you when you know the national examiner can just disagree? Does it change how aggressively you amend claims before entering the national phase?
Or maybe flip it around. Think about the system design. Why is the IPR non-binding? What are the pros and cons of having different national offices acting as IPAs, even under the PCT umbrella? Does it truly lead to harmonization? Or does it introduce its own complexities because different IPAs might still have slightly different approaches or interpretations, even subconsciously?
Yeah, those are the kinds of strategic and systemic questions that understanding the role of the IPA, as laid out in sections like 1862, really starts to open up.
Absolutely. Well, hopefully this deep dive into MPEP Section 1862 has shed some light on this part of the PCT process. Thanks for joining us, and we'll catch you next time as we continue exploring the MPA.